the Wednesday before Thanksgiving. So I know a lot of people are either busy traveling or getting ready for Thanksgiving festivities. So as people are joining, give it a few more minutes and we'll get started. We probably won't have a big group today, but it's an important topic. So I hope folks will join. With the new DOL wage increase, this is very critical. So let's go ahead and get started. And if people happen to join in, they can join in later. But welcome, my name is Lakshmi Challa to our weekly Challa Law webinar on immigration. And for those of you who are joining the first time, welcome. For those of you who have been with us to, joining all our webinars, thank you for your support. We strive to provide critical information for the hot topics that are impacting people's immigration process today. And so, as we know that the increase in wages has really been a difficult thing for people to grasp with, especially because it was issued, without notice and without a time period to adjust, and with extensions or amendments on the horizon, you're subject to the new wage, DOL wage that's outlined. So that's the focus of today, to get started on some of that. Now, there are different ways to connect with us. There'll be a lot of changes, especially with the new administration. So please make sure to connect either on Facebook, Twitter, Instagram, YouTube, LinkedIn, and then we have a Telegram group. So if you haven't joined the Telegram group, please do. I think they've just shared the links on chat. If you have any questions, please place those questions in the Q&A and not on chat. It makes it easier for us to address them. And we will, as we do always, address those questions at the end through the, through the moderator. So, view recordings of our previous webinars. We talk about really critical information like Dropbox, the ability to do the Dropbox or emergency appointments, whether you are looking to start your perm and how you should craft your job title and how does that interconnect with the DOL job titles and issues that you may face on the next stage. Because a lot of people, you have to proactively draft your perm with the entire process in mind so that you don't come up with any problems down the road. So we've got some really great proactive approaches to make sure you have a seamless permanent resident process. H-1B RFEs, we've got a session just on that. So take a look at the webinars. People have told us that they found it to be very helpful and clear, and it gives you great guidance no matter who your attorney is, so that you can be in charge of your immigration process. And if you like it, please subscribe and share it with your friends. Comment. I love to hear back from all the people that are listening to the webinars. So please do that. So as I said, today we're going to talk about alternative wage surveys to address the increase in the DOL wage surveys, insight on some challenges to the proposed rule and some other updates. And then we'll go into questions. So let's get started. Prevailing wage. So, when an H-1B or when you're going through a perm process, one of the agencies that you deal with is the Department of Labor. Department of Labor wants to make sure whether you're filing for an H-1B or whether you're filing for a perm, that you're not displacing U.S. workers with cheap foreign labor. That's the whole premise of it. They go about it slightly differently. So with the H-1B, you file an LCA where the employer is attesting under penalty of perjury that they're not displacing U.S. workers. There's no strike or lockout, and that they will pay the prevailing wage. So the DOL relies on the Bureau of Labor Statistics for the prevailing wage data, and there's a certain way in which they've always calculated it. And I read through the DOL regs the other day, and it's ridiculous the kind of justifications they have for their current analysis of why they need to redo the way the wage is increased. So there are multiple legal challenges, but until those challenges, until it's enjoined, we have to, this is the reality in which we deal with. So you can use sometimes a different SOC code. So when you're filing, let's say you're filing for an extension and that wage rate is a little high, you can file maybe a different code, that because there's some of the codes where you can use one or the other, and that may impact what your wage is. And alternatively, you can use an alternative wage survey, but it has to meet the regulatory criteria. You can't pick any wage survey. So with option 1, less common SOC codes, you have to make sure that that it's still consistent with your job duties. There are two things that are in interplay with the SOC codes and the change in that. The DOL, the memorandum that addressed all this, talked about how, it may raise a flag, but we've got a new administration that's going to be in place. So I encourage everyone, if you're filing an amendment or you're filing an extension, don't do it premium, do it regular processing, wait for the new administration to get settled, and then upgrade. Because all of these issues may be addressed, with the new administration. So alternative wage surveys. So the employer is allowed to use either an independent survey or the employer's own survey. The employer's own survey is sometimes problematic because you've got to get it certified by the DOL, but you can use an alternative wage survey as long as it meets the criteria. So you have to look at, usually those wage surveys cost additional money, but in the long run, if you look at the increase in wages, it still may save the employer to utilize that. There are commercially available pre-existing surveys. Now, private surveys, like I said, have to abide by the regulatory requirements, but Towers Willis Watson is one that has been utilized a lot. And you have to keep what the methodology it is, because that's one of the criteria in the public access file. So you want to look at that before you pick a wage survey, alternative wage survey. So, as I was saying, in the public access file, you're required to keep a general description of the wage survey source and the methodology that's required. And usually when you buy an alternative wage survey, and the ones that have been used for H-1Bs, they know that, so they will provide that for you. So that's in addition to everything else. So the survey requirements, you have to have the name of the survey. The publication date must be on the survey. So if there's a new release of the survey, then you have to use the latest survey that is provided. You have to outline when the data was collected, the description of job duties to make sure it matches up. The sample size that was used, how many participants, the methodology of the wage survey is important. And, how many responses that they had, what's the geographic area? So remember that for H-1Bs, it's geographic specific. So you are allowed to use surveys that deal with the MSA, but in the survey, it has to be, there's some that will say a region, Southeast region. That wouldn't be permissible. So it has to be at least within the MSA. And whether the survey was a mean or a medium, and whether there's a cross industry nature of the survey was maintained, that is, did they have an appropriate pool of people that, people that they surveyed. And any explanation of any variation beyond that And like I said, most surveys that have been used for H-1Bs, and we used to use them quite a bit previously because back in the day, you couldn't go online and get the OES survey. You had to file a prevailing wage request, and you'd actually have to type it in. They didn't have it, there was no program for it. So you would type in the information on the way through, you'd write it in, and then you'd submit it, and then you'd have to wait for DOL to issue the survey. So because that was taking so long, what we started using was, back then it was Watson Wyatt, and the employer would just buy a subscription to that, and then we would use that for all their LCAs. So that's the thing on the survey. So you can use them. Make sure you learn the methodology and that it's consistent with the requirements of the H-1B. You have to make sure that the employer keeps the methodology in your public access file in case it's questioned. But that could be a good option right now as we're trying to wait for, like I said, the administration to change. And I'm pretty sure that this is one of the key things that's going to be addressed by the Biden administration. But we have till January 20th till we wait for that. So there's some immigration updates. The district court prohibits the Department of State from suspending K-1 visa processing pursuant to the President Trump's proclamation and entry during COVID. The court didn't tell the DOS to adjudicate it within a specific time frame, so I suspect until the new administration comes into place, this would continue to be at play. Oops, I skipped over one. The non-immigrant update, there's a temporary rule effective for 6 months that it's called for visitor visas, whether on a B1 or B2. It doesn't affect India, China, Europe. It's just countries where they have found there's a larger instance of overstays. And so they are going to mandate maybe a bond that's put in place before the visitor is allowed to be issued a visa. So the bond would be with the USCIS. And this is a way they feel that this is a mechanism to ensure that these countries where there's a large instance of overstays don't overstay. Like I said, it does not apply to India or China or most of the European countries. So like I said, B1, B2, they haven't really stated what the amount is for the bond, but anywhere from 5,000 to 15,000. And that is it for the updates. We wanted to keep it short. We know that everyone's getting ready for their Thanksgiving holidays. We thought we would make sure to give time for a brief Q&A. And we look forward to talking to you next week. I'm sure there's going to be some additional immigration issues to be addressed, and we may pick one particular topic to go over and discuss, one process. So let us know if there's something that you would like us to discuss next week, a particular topic or a process. It doesn't have to be an update, but even just something like issues for visa processing or what to look out for, again, when you're addressing RFEs, because of the new changes that are going to be taking place effective December 7th, which may be a real focus of our discussion. If you haven't joined us on the Challa chat forum, please do. We've included the links in chat so you can join and get some of that's where we're actually posting our immediate updates. So that's a good place for you to get the latest update. And different ways to connect. This is, like I said, you can connect with us on Facebook, Twitter, Instagram, YouTube, Telegram. We gave you the link, and take a look at our YouTube videos that are already up there. They're chock full of information and resources. And like I said, our primary objective is to make sure that you get clear immigration direction as you're navigating through this very difficult process. And so with that, and there are where you can get our previous recordings. If you've got any additional questions after we go through this Q&A, email us at info@challalaw.com, and we'll be happy to provide whatever guidance we can. So with that, let's go ahead and start with the Q&A.
Hello, good afternoon, everybody. Wishing you a very happy Thanksgiving ahead of time. Be safe, maintain your social distance, and still enjoy. So let's start with Suresh M. And his question is, good morning. If DOL approved LCA based on alternate wage level survey, then USCIS has to honor that approved LCA for H-1B, or they can raise concern as it's not matching with new DOL wages. Thanks.
Well, that's a good question. So DOL will certify it based on the information you put in, but they won't look at the underlying methodology, right? But the USCIS may ask for that, especially now. Typically they didn't, because that's really within the purview of the Department of Labor. That's why I'm telling everyone to file their petitions regular processing, not premium processing, because you want to wait till the new administration comes into play, where I think you'll get a much more favorable review of your petition. But, you know, instances like, you know, if you change the SOC code or some variant, and I suspect when the new administration takes place, because they know that President Trump's administration had revamped basically the wage levels without notice, that a lot of those issues will be excused. So we'll have to wait to see how they address it. I know for a fact that the tech companies have really put a lot of pressure on the Biden administration, in addition to the universities, healthcare institutions that rely on really key, highly skilled individuals that may not be paying the new wage that's outlined. So I think that this is going to be nullified. So yes, if you've got the Department of Labor certifying, make sure it still meets the criteria that is required in terms of specific geographic area, using the mean and median, the latest survey, make sure you have the methodology in which they used. And then I think you should be in good shape.
All right. Next one is Arjun G is asking, I have a question on maintaining H-1B still after GCEAD. Why we need H-1B if we have EAD? To support my point, let's say if GCEAD rejects, denied, the underlying I-140 also got revoked, not legitimate. That means whoever on H-1B 6+ would also use same I-140 to extend H-1B after 6 years. So this means H-1B should also revoke, isn't it? Please shed some light on this.
Yeah, no. Remember that unless it's fraud or misrepresentation on the I-140, if your employer revokes it, you're still eligible for extensions beyond the 3 years. If it is, you know, so, and then here is where it's a question of timing. So, and there's a couple of different scenarios. So if you have an H-1B and you have an EAD that you can use for employment authorization, if for some reason the USCIS makes a mistake in denying your adjustment or your I-140, they have been known to do that. You can get that corrected. And in the interim, you will have a work authorized status, i.e. your H-1B. If, for example, they deny it because of the documentation you submitted for ability to pay wasn't strong enough, you'll get an RFE and afterwards they'll deny it. But you can refile that with new evidence and new information. And if you're on an H-1B, you have that as your safety net. So there are instances where you can still leverage the I-140. And remember, there are instances where the I-140 can be approved, but they deny the adjustment of status. So if they deny the adjustment of status, that's where the problem is. So if the I-140 is denied, of course, the adjustment of supporting adjustment of status will be denied. But they can also just deny the adjustment of status. And I have seen in my 25 plus years, there have been instances where there is a mistake. And you can, like I said, get that corrected, but wouldn't it be great to have not worry about your current status while you are already stressed and trying to correct the other issue?
Okay. Next one, as an anonymous attendee, did any of your clients receive receipts for the EB2 to EB3 downgrade or have their checks encashed? Are seeing any rejections of these cases at the mailbox?
Yeah, we haven't seen any rejections, and we are, a lot of our checks have been cashed, in fact. And so what we're doing is on back of the check that's been cashed is the receipt number, not the receipt notice, but the receipt number. And we've been sending that out to our clients so they can feel comfortable that their petition application was received.
Okay. Next one, anonymous attendee, can I still retain my I-140 priority date if my I-485 AOAS will get denied in the worst case, assuming that already used EAD and AP and no underlying non-immigrant H-1B status? Can I still retain my I-140 priority
Right.
date if my I-485 AOAS will get denied in the worst case?
Right. And so we did a webinar, I would say it was probably early October, on the instances where your priority date won't port with you. And the main instance where you no longer get the availability of your priority date is if the denial was based on fraud, misrepresentation, or that they re-adjudicated it and you shouldn't have been issued that I-140 to begin with. And we go through that in great detail. So I would tell you to take a look at that because it goes through it. But if it's not for those reasons, then you get to your priority date vests with you and it won't be taken away.
Okay, Vijay Somisetti is asking, can you let me know what is the difference between executive order and an interim final rule? What I heard is it is easy to overturn an executive order by the next president, but not an IFR. If that is the case, why did Trump choose IFR for some and executive route for some of what we wanted to achieve in terms of stopping immigration?
Okay, that's a good question. And we did talk about the differences in one of our previous webinars. So the president through the INA only has the authority to control the entry of non-immigrants. He can't control anything, even with that broad authority, on people who are already here or agencies who are already here. The president's executive orders can only control entry into the United States. Okay, that's number one. Number two, the interim final order that was issued for agencies, they have to go through, they have to adhere to what's called the Administrative Procedures Act. That's all federal agencies. Administrative Procedures Act, the APA. And there was a Supreme Court decision last year, 2019, Kaiser versus, I can't remember who, but the Kaiser decision, the question was, how much judicial deference does a court have to give an agency decision, right? Because typically agencies are given vast deference. That means if they make a change on procedure or certain things, then a court should not review that. That's basically it. But there's certain things that the agency cannot do because they have to abide by the APA. One of the big things that they can't do is they can't step in and legislate. That is within the jurisdiction of Congress. So anytime a agency change is challenged, the Supreme Court will look at whether if it was very explicit that Congress addressed this issue and spoke on it. So what the Kaiser decision said is the only time that the agency would be given deference on certain things is if the definition or the issue is ambiguous. Okay, that means, you know, it's subject to interpretation. But if it's not ambiguous, then they will look to see what the clear construction of that word is. So for example, specialty occupation. Specialty occupation, and I went back and I looked at that term only came about in 1990 when President Clinton, you know, issued IRA. And when Congress went through defining what specialty occupation was, they were clear that they wanted to say that it should be related to a specific discipline. They didn't say degree. They said discipline. The new regulations, they're trying to tie it to a degree. And in fact, Congress stated there are going to be instances where, for example, a general degree like business administration would be permissible because the individual would have years of experience in a very specific field that would give them the ability to undertake the job duties. So by narrowing that definition through this final order that is going to be effective December 7th, the agency overstepped their bounds. Number one, it wasn't an ambiguous term. Number two, Congress directly addressed this and spoke. So it is beyond what the agency is permitted to do. It is eventually going to be overturned. But even before that, January 20th, I think you'll see the new administration, you know, invalidated. So to go back to your question, it's not that one, the executive order or an interim final order, either one is easily overturned. An executive order, unless it's challenged, and they have been challenged. Remember the initial Muslim ban, and I hate using that word, but the travel ban was overturned until they redid it and redid it and redid it. On the third try, they made it narrow enough that it was eventually upheld. So both the executive order and the interim final order can be overturned. It's just the jurisdiction or the authority that the president has is limited to entry.
Okay. I would just want to remind viewers or attendees to put your question in the Q&A and not in the chat. And also, we are answering questions in the way they have been put in the Q&A box chronologically. So if you're going to repeat your question again, it will just confuse us. So I would really appreciate if you just, you know, put your question and let me get to that in the chronological order that I see on my window. Appreciate it. Next one, anonymous attendee. Can we take COBRA health insurance benefits from previous employers? Will it impact H-1B and green card process?
No.
All right. Sagar Kulkarni is asking, I'm working at an end client location for the last few years, and as a result of COVID, we were asked to work from home. Since my home is located within commuting distance, my employer asked me to post LCA at home and send a picture of it. Now the client company has decided to go virtual permanently, meaning we will be working from home from here on. And then he says, I'm due for extension, and at this point, should my company be filing an extension or an amendment plus extension at this point? Thank you very much.
Well, if it's within the same MSA, they don't really need to file an amendment because you're not really amending because you're not required to amend. But when they file your extension, they would list the home address instead of the employer address because you've gone virtual permanently.
All right. Anonymous attendee is asking, my last H-1B extension was in wage level 4. Applying H-1B extension by next week in wage level 3 with a different SOC code in regular processing, LCA got certified. Any possibility of RFE from USCIS for my case?
No, I think the new administration is going to address the new wage levels and all these other things. So I think you'll be okay. I don't think, because if it's going to be invalidated, even if the USCIS asks, because there's going to take some time between the new administration's and the training of the USCIS, but you would be able to justify it because of the unlawful new rule that has been implemented immediately without notice and comment.
Rahul is asking, any update on wage level court case?
Not yet. I know that but with all these holidays coming up, nothing of critical importance to report.
His follow-up question on topic recent regulation that mentioned about 485 AC 21 job portability has to be similar or some profession. Did they also mention about pay scale, or do we have maintained it certain level, and does it have match current pay or pay mentioned in original label?
I would tell you that if you didn't listen to our webinar last week, to go back and watch that, because it's not a one single process. So there is the eligibility, and there is what the USCIS can use as deference. So go back and look at that, because there are a number of factors. Before, wage wasn't a factor. Before, as long it was same or similar, they didn't look at things like SOC code and other things. They just looked at the overarching duties, and they understood that if you're doing this for 10 years, you can't necessarily have the exact same job duties as when at the time of filing. So look at that. I've got PowerPoint that kind of really goes into that, and that should help you out. It was last week's webinar.
Next one is an anonymous attendee is asking, if I'm working for a client from home permanently, is that considered a third-party placement too? Before I was going to the office location, same as MSA as home. Will I need an amendment during my next?
No amendments needed when it is within commuting distance or it's within the same MSA.
Okay. Anonymous attendee, I don't know if it's the same person you just asked. What will happen to my I-485 AOS in case I will go back to my home country for emergency? Will not come back to US at least for 1 or 2 years, and already used my GC EAD when working in US. Can I still renew EAD and AP from home country and return to US?
You can, there's going to be an analysis of whether, you have abandoned your intent to reside here permanently or not. So I think that's going to be a bit of the challenge until it's approved. After it's approved, of course, you can get a re-entry permit and stay outside the United States for 2 years. But if you're not interviewed and there's no RFE, technically speaking, there won't be an issue. But if you are, and there is an RFE, they will look to see if you truly intend to permanently reside here.
Okay. Next question is from Pinal Patel. International student population is trying to figure out how to navigate through immigration process. If you can touch on this in your future webcast, much helpful.
Absolutely. So if you would go ahead and email me, I will set a date just to address that. And then you can let all your contacts who are concerned about that know, and so we can touch on that either end of December or early January so people can prepare for H-1B cap season.
All right. Suresh Shastri's question is, my PD is October 2010 EB2 filed for AOS this October and received receipt. I have received a layoff notice from employer and has given notice until end of this year. Should I wait 180 days before I use my EAD AP combo card? What is my status from January to end of April if I don't find an employer who can transfer my H-1B?
Right. So remember, and we went over, I think a lot of people had this question last week. In order for you to go through portability, that means not have to go through the permanent residence process again. Two things have to happen. One, your I-140's got to be approved. And two, your adjustment of status has to be pending for 180 days. That means if you change employers before that time, you get to keep your priority date, but you will have to go through the permanent residence process again.
Anonymous attendee is asking, does applying and getting unemployment benefit from state can affect future H-1B transfer?
Well, remember, you only have 60 days where you can be unemployed, and you buy into unemployment. I mean, part of your payroll, you pay into that so that it's not deemed public charge, but you are limited when you buy that 60-day grace period before you change status to something else or find a new employer.
Okay. Anonymous attendee is asking, what are the possible reasons to deny the AOS petition at lockbox?
At the lockbox? You mean
Yes.
reject? They'll reject
Deny
it.
the AOS petition at lockbox.
Yeah, so the lockbox, what they will look for is are all the signatures in place? Do you have the correct checks? Do you have a basis for filing the adjustment, if that's clearly outlined? So they look at the very basic things. They don't delve deep into it, but it's signatures, correct jurisdiction, making sure all the forms, the base forms are in. The checks not only are signed, but they are addressed to the correct United States citizenship and, or Department of Homeland Security. And then that it's the check amount is correct.
All right, next one is from Jay Agnihotri. Good afternoon, Ms. Challa. Thank you for your time and guidance. Our applications for I-485 EAD AP was delivered by FedEx per the tracking information, but USCIS apparently found an empty packet. We are not sure if it has been lost or just misplaced among the thousands of applications. Check has not been encashed yet. We heard that filing again could end up becoming messy. What is your suggestion? Do I wait for them to find the application on their own? Do I just reapply? Is there a way to push the Texas lockbox facility folks to find our application somehow?
Right.
If
I
so,
would,
how?
yeah, I would say I would put together a very clear letter with any communications that evidence that shows it was found. Now, here's a couple of ways in which you have that evidence. Number one, it's the FedEx. Number two, FedEx would assign a weight to that envelope, right? So there, the cost of the FedEx is dependent on the weight. So they weigh everything. So if you can find out what the weight was, clearly if it's an empty box, it would weigh this. If it was something else, it would weigh this. And I would make an argument and resubmit. I wouldn't wait. I think if you can make a clear argument, then and then tell them that because they made the mistake, they need to accept this filing because it was filed timely.
Yeah, he just added saying applications were sent 5 weeks ago, just a timeline. So
right. So like I said, if it was sent by FedEx, it's all of these services, UPS, FedEx, it's based on weight. So you would, you can get on site, ask UPS, and you Google it, how much, I mean, what is the weight of an empty FedEx envelope? You find that. Then you find out how much FedEx charged you based on the weight of your package you sent. So then the differential would clearly, I mean, these packages are this big. It's not, it's going to be a substantial cost. So that would be clear evidence that what was dispatched was a full petition. And then you submit information about the fact that it was received by the USC, I mean, the lockbox. So you have proof of that. So then you say, it's not my fault, you lost it. Here's proof that it was submitted this way, pursuant to the, FedEx. They weighed it, and this is how much it weighed. An empty box is this much. So clearly it's not going to, I sent a full petition. You received it. We've got proof of receipt. Here is a copy of the petition that we submitted. Since you made the mistake, lockbox, you need to receive it. You need to accept it.
So he should just send another FedEx.
Yeah, but he should make the argument. He's got to make the argument.
Attaching the duplicate copy and arguing his rationale as to that he sent it on time and this is the weight and here is the receipt. The receipt shows this is the weight.
Yeah, because
delivered empty, or if they found an empty box, that means something happened
at their end. Yeah. So,
So
and
you
that's
can
the
just,
best way you can,
make that
Because what they're-
argument.
yeah, what they're trying to say to you is maybe you send us an empty box, but FedEx weighs everything. So you have credible proof, credible evidence that that it was sent with a full petition, assuming that it wasn't a mistake that the law firm made.
Yeah, I don't know, Jay Agnihotri, where you are right now, which part of the country. And if I were you, I would just draft this letter, make a copy of that, and go to FedEx and drop it off today.
And I'd first find out, have your lawyer's office send you, if they sent you the confirmation of the FedEx, you should be able to see on there what the weight of the package is. If you have not, they would have that on their end. So that's where you start from. You want to make sure that it wasn't a mistake by the law firm, not including the package in the FedEx.
Yeah.
But you start with that and then work your way through. I hope that helps.
Yeah, just act fast. Okay. Suresh Shastri is back. He says, my I-140 approved with my current employer since 2014, and I have worked with them all along. Can I travel outside USA when I receive my EAD card? Approximately how long is it taking for issue of EAD card?
Yeah, it's not your EAD card that will allow you to travel. It's the EAD AP card. So it's the AP portion. It may take, it was taking long anyway for others. You have to go through your biometrics. So it won't be until after your biometrics appointments, which are delayed. So I'm thinking maybe anywhere from 6 to 8 months before you get it at this point.
Next question is from Mariangala Basi. Good evening. I'm here to ask a question on behalf of my son. He's in the US and with F1 visa, which will expire in February 2021. Not having a sponsor, is he going to ask a visit? Is he going to ask a visitor's visa? What would it be okay?
The visitor's visa, first of all, it takes so long to get that adjudicated, and I would have him join another academic program. There's a lot of one-year programs. Get into another academic program so that, there's really nothing he would have to file. He would just have to get a new I-20 and then update, the new institution would update his SEVIS record. And that way, because, first of all, it will take more than 6 months to adjudicate a change of status to a visitor visa. Most likely it may or may not get approved. But if he joins a 1-year program, then he doesn't have to file anything. And so if he's looking at sponsorship opportunities, he would get that. And you said his program, did she say his program, F1 program ends in?
No, I think the F1 visa expires in 2021. So I'm
Yeah,
not
it's not
sure.
the visa, it's the I-20 that controls.
Yeah,
Is if he's in the United States, you don't need a visa to enter you don't need a visa to reside in the United States. You only need a visa to enter the United States. So as long as his I-20 is valid and he's maintaining full-time F1 status or OPT, then he is within, he's maintaining status. So the fact that his visa in his passport has expired is not relevant.
yeah. The February 2021, if I understand, because I come from an academic background, unless it's some special program, either it ends in December or it ends in, May, fall or spring semester, right? Any program. So that means your son has, validity till, spring 2021, which is April or May, when the semester ends. So another advice I have is, just to piggyback on what Lakshmi said, it's not very clear whether he's on F1 or he's on OPT. Assuming that he's on F1, still has OPT to apply, he can apply for that. Or as Lakshmi suggested, let him go join another academic program. And based on, let's see if he can join a STEM program, STEM, Science, Technology, Engineering, Math. What that does is it gives 3 years of OPT as opposed to 1 year. So I'm not sure what his major is, but just a
Yeah, and I think the other thing I'm not clear of is when she says visa. Visa is a stamp that the Department of State issued in the passport for his entry to the US. That doesn't govern your immigration status in the US. That allows you to enter the US. What governs your status is your I-94 card. And for F1 students, it typically says D/S, duration of status. Duration of status means you either have to be in full-time academic program or you have to be an OPT.
Yeah. So if you have some additional follow-up questions, send an email to info@challalaw with details, and maybe that would clarify some of the doubts we are expressing here. Jay Agnihotri wants to thank you for your suggestion on a lost FedEx package. Next question, an anonymous attendee. My mother is a visitor on B2. Can she leave back to India without getting fingerprint applied for renewal, but they did not send?
Yes, I would just make sure that you give her proof that the extension was filed timely, so that next time she comes back in, she'll be able to show them proof that she filed a timely extension, but it wasn't adjudicated and she wasn't fingerprinted.
Next question, another anonymous attendee. EB3 filing dates has retrogressed in the current visa bulletin. Do we expect the same in the next visa bulletin until October 2021?
Yeah, not probably as much as this month. There's not going to be as many filings this month as there were last month. So you may see somewhat of a retrogression, but not as substantial.
All right, next anonymous attendee. I've sent my OPT application to USCIS last week. Now, what is the next step? When do they respond? They have received the application, and how much time will it take for them to notify me? Please help.
Right. Well, if your checks are cashed, they've received it. There are extraordinary delays with biometrics and with issuance of EAD cards. So, typically they would do it within 3 to 4 months. I'm seeing 5 to 6 months. It may be greater. There is a lawsuit challenging the USCIS for these ridiculous delays. So we have to see how that pans out and whether that would force them to process these more expeditiously.
I think is the same person, anonymous attendee, is saying, I've sent money order for the same. I don't know if that makes any difference.
Yeah, money order you can't track or trace. I would never have sent a money order. So I guess you're just going to have to wait for the receipt notice. If you've sent it by Federal Express, I hope that you sent it by some type of mail where you could confirm that it was at least received.
Okay. Let's see. Next one. Well, he said, I think he or she said they sent by UPS. So.
Yeah, so you should be able to track it through UPS and see if it was delivered.
This person is saying, okay, they received it.
Okay, so you got to sit tight, buddy. You just got to sit tight. Yeah. There's nothing else that can be done at this point.
That's all the questions we have for today. So.
Very good. And so I know there was one suggestion that next week we talk, that in our upcoming sessions we talk about issues that impact F1 students. We'll do that. I think next week the topic is going to be about, the new December 7th regulations and some strategies to address, the new rules, and any other updates we have on adjustments or, any new regulations that are going to be put in place. We understand that the administration is going to keep on trying to change institutionalized changes in immigration before year end. So I'm pretty sure we're going to have something else to talk about. But I hope you all have a wonderful Thanksgiving. Thank you again for joining. And if you found this helpful, please share it with your friends. That's the only thing I request is, help me spread the word. And so I can continue to, so we can continue to provide these updates and hopefully give you some clear, actionable advice on your immigration process. So till I see you next week.
Yeah, if we're going to answer your question, then just send an email to info@challa.law, just in case if I missed, by mistake or what have you. Or if you need further clarification on some answer that the attorney gave you, send info@challa.law.com. Thank you.
Have a great Thanksgiving, and I look forward to seeing you guys again. Thank you, Shaker, for your moderating.
Thank you. Glad to do it.
And you have a great Thanksgiving as well.
You too.